Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. It is Thursday afternoon. I'm sitting here in the studio. Yes, I got playoff baseball going right over there on the TV. Was doing a couple other videos, got notified that there is another assault weapon ban case that is headed to the United States Supreme Court. This is the one that comes out of Connecticut. We've talked about this case before. It's actually a challenge to both Connecticut's assault weapon ban and magazine ban. It was in a preliminary injunction phase, and now it is headed to SCOTUS. What does that mean? What does the petition say? That's what we're going to talk about today. So today, let's spend a few minutes and let's talk about another assault weapon ban heads to the Supreme Court. Okay, America, listen, we're talking yet again about an assault weapon ban and a magazine ban heading to the United States Supreme Court. Why do we think it's going to be any different this time? I don't know, but at some point, something's got to pop. The case we're talking about is National Association for Gun Rights versus Lamont. It, of course, is brought to us by our good friends over at NAGR, which means there's a link down below for you to show them some love. Now, this was a denial of a preliminary injunction that was then appealed to the Second Circuit. So we got to acknowledge that this case is still in an interlocutory fashion, which doesn't bode well for acceptance. But the Second Circuit upheld the denial of the preliminary injunction, finding that even if arms are in common use, such as semi-automatic rifles or magazines that hold more than 10 rounds, it does not mean that they cannot be banned. That is actually the ruling of the Second Circuit here. And so for that reason, one of the big themes in this petition, of course, written by one of our favorite brief writers, Barry Arrington, is hey, you know, the Supreme Court, they're just thumbing their nose at you. They're just making up new rules of law, and you guys are letting them get away with it. The question presented, which is always the important way of framing the issue, reads as follows. This court has held that arms typically possessed by law-abiding citizens for lawful purposes are protected by the Second Amendment. The Second Circuit disagrees. It wrote, even assuming arguendo that the desired firearms and magazines are typically possessed and in common use for lawful purposes, we disagree that they are necessarily protected by the Second Amendment. What you say? Yeah, that's right. That's literally where the Second Circuit came down. They flat out ignored clearly established case law, which leads the petitioners here to present the question presented as whether a ban on the possession of AR-15 style rifles and firearm magazines with a capacity in excess of 10 rounds, both of which are possessed by millions of law-abiding Americans for lawful purposes, violates the Second Amendment. Now, listen, we're not going to go through a whole chunk of the petition here because you guys all know the arguments. You're here geeking out with us all the time. But one of the things I need you to understand is the Second Circuit had basically said, hey, listen, common use, schmommen use. It doesn't really matter, okay? Because we believe that if a firearm is uniquely dangerous, it doesn't matter how commonplace it is, it can still be banned. What case law did they rely on that? They didn't, because there is no case that says that, which of course leads the petitioners here again to point out, then under the guise of performing a search for historical analogs in the challenged statutes, the Circuit Court engaged in an interest balancing analysis that was practically indistinguishable from the intermediate scrutiny analysis it performed before Bruin. The result of that interest balancing inquiry was not surprising. The court held that the challenge statutes are likely constitutional because the arms they ban are unusually dangerous. In other words, the Circuit Court did the very thing Bruin specifically prohibited. And the panel's assertion that it may uphold an arms ban, even if the banned arm is in common use for lawful purposes by millions of law-abiding Americans, is probably the most flagrant violation yet of this court's Second Amendment precedents. I mean, think about it. They literally had said, yeah, we understand there's a case out there called Heller, and we understand the common use doctrine, but we're going to flat out ignore it, because that's exactly what the Second Circuit did, which leads people such as Justice Clarence Thomas to have previously pointed out. Justice Thomas has observed that further percolation in this area of law is of little value when lower courts in the jurisdictions that ban AR-15s appear bent on distorting this court's Second Amendment precedents. This observation is even more true today. Indeed, it is difficult to imagine how a circuit court could distort Heller's plain holding to a greater extent than the Second Circuit did in this case. And then a large portion of the brief, and we're not going to get too deep into it because we actually have another video coming out on it. It's still sitting on the editing board, but this whole notion that there's not a circuit split when it comes to magazine bans or assault weapon bans, but there may not be a circuit split, but there is what we call, pardon my language, a circuit, which is that these courts are all over the board about whether or not they can deny it in the text portion or the history. They're all over the board about when their in common use comes in at the text portion or during the history. They're all over the board. And so we may not have a split as to the constitutionality of these bans, but we sure do have a split as to what creative and imaginary rule of law can be used to uphold these bans. Okay, the petition was just filed. We'll carefully watch this case. Now, I acknowledge this case is still in an interlocutory fashion, which does not bode well, but then I've noticed that if it's an assault weapon ban or a magazine ban, it doesn't necessarily bode well at all. We do have other cases up there right now, including Duncan v. Bonta and the Gators case out of Washington, both of which deal with magazine bans. And we do anticipate we'll be getting another assault weapon ban one way or the other out of the 7th Circuit in relatively short order. Okay, the case once again is National Association for Gun Rights v. Lamont. The brief is authored by Mr. Barry Arrington, so you know it's a good read. Listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. Down there in the description box, if you got an idea for a video, you click that link, you tell us all about it. If you're interested in the monthly newsletter, you can subscribe on the link down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.
Therein lies why we say in the legal defense sector that we are the most value-centered, cost-effective legal defense in the space, and we are. There's no question. Now, again, I've said before, we've got great competitors out there. They have outstanding products. We admire them. They pave the way for us. You know, we analyze the folks out there that are doing the same thing we're doing, and we took some great ideas from them, and we went down a path of believing that we were going to do it with a service aspect, a servant's heart, and we have again. Our number one goal has been to serve others first in a way that the industry hasn't seen.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.